Hello students, welcome to the lectures of corporate laws and compliances. Let's start with a new topic today, that is insolvency and bankruptcy code. Okay, so I have divided this chapter in few parts. So today we are going to discuss first with introduction to IBC, where we're going to see the concept that what is basically insolvency, what is bankruptcy, and how this code is developed, what is the history, why this code is being developed, okay, what was the reason to incorporate this code, who is the appellate authority or adjudicating authority behind this code, okay, what is the commencement date, and all these things we're going to see it today. So let's start with straight away with the topic. First of all, let us understand the two concepts, that is insolvency and bankruptcy. Generally, when an individual, the term insolvency can be used for individual and organization, or you can say company. So when individual become insolvent, first of all, what do you mean by the word insolvent? Insolvency means when the assets of the company or individual or body corporate becomes lower than their liabilities. Suppose asset of the company is 1 lakh and liability is 2 lakh. So this minus 1 lakh is basically excess liability that the company has. And when company declares that it is unable to repay such a extended liability, then such company will be considered as it has become insolvent. Okay, so let us see what is written here. It says the term insolvency is used for both individual and organization, that includes company, body corporate, firm. Okay, for individual it is known as bankruptcy, and for corporate it is called as corporate insolvency. So both refers to a situation when an individual or company are not able to pay the debt in the near future and the value of their asset becomes less than the liability. So basically they are become unable to repay the debts, the loans or the borrowings that they had taken from different people. So they are not in the position to repay it. Okay. And insolvency in the code is regarded as a state, that is a situation where the assets are insufficient to meet the liability. So where the company's assets are not proper to meet the liabilities of the company, that I had already explained. And if it is untreated, if the insolvency is untreated, that is if there is no action taken to meet the liability of the company, then it turns to bankruptcy. Okay, for non-corporates and liquidation for corporates. So basically when an individual is unable to repay its debt at any position and there is no chance of compromise or arrangement so that this debt becomes lower or the insolvent individual is able to repay the debt. So there is no situation like that it is able to repay it, then it will turn, this insolvency will turn to bankruptcy. And when an organization is in a similar position where it is unable to repay its debt and its liabilities got more than its asset and it is unable to repay those and there is no compromise that can be done on the same, then such insolvency for corporate will be known as corporate insolvency and it will turn into liquidation. So it is a state when an individual or company are not able to pay the debts and value of assets are less than the liability, and if it is untreated insolvency, that is insolvency is not treated in order to repay the debts, then it will lead to, for non-corporates, it is bankruptcy. Non-corporate means individual, or you can say partnership firm also can include in it. And for corporates, that is company, body corporate, LLP, it will turn into liquidation. That is like a winding up of the company or dissolution kind of thing, which is also named as liquidation. Okay. Now, while insolvency is a situation which arises due to the inability of the debt due to insufficient asset, bankruptcy is a situation wherein an application is made to an authority declaring insolvency and seeking to be declared as bankrupt, which will continue until discharge. So this liability will be continued until it is discharged. So from the above, it is evident that insolvency is a situation and bankruptcy is a conclusion, because when a situation arises, then it comes to a conclusion that may be a bankruptcy or a liquidation. And a bankrupt could be a conclusive insolvent, where all insolvencies will not lead to bankruptcy. So basically, conclusive insolvent, that is where if insolvency basically get rectified, then there is no situation that will come for bankruptcy. But whenever a company or a person becomes bankrupt, then that there is a 100% a situation that a person has got insolvent. So all insolvencies are not bankruptcy, but all bankruptcies are insolvency. Okay. And typically insolvency situation have two options. Either they can go for a resolution, and it can go for recovery or liquidation. And this code, IBC code, gives solution for both, that is resolution of the insolvency and recovery of the insolvency, or it may lead to liquidation of that person. Now, what is the relationship between these three words? It looks into like very similar words: bankruptcy, insolvency, and liquidation, but there is a certain relationship between that. What are they? Let us see what is written here. It says bankruptcy is a legal proceedings involving a person or business that is unable to repay the outstanding debt. So basically, when an insolvency has taken into the courts, basically to IBC, and a situation arises when a person is unable to repay the outstanding debt, and that is on that basically the legal proceedings has been commenced and a conclusion has been come, then it will lead to bankruptcy. A conclusion, what conclusion has been come? That the person is unable to repay the debt, and now we have to find certain solution to bring this liability at such discharge need to be done, that is such payment need to be done for that meeting that liability, and that will discharge the particular company also. Suppose, for example, one second. For example, this is Mr. A and this is A Limited. Mr. A has given 1 lakh rupees as loan to A Limited, and asset of A Limited is 50,000. So even after paying the asset, the 50,000 money is still left to be paid, and now the A Limited is saying that I don't have any more money to repay this amount. So Mr. A can apply for bankruptcy in the court against the A Limited, that he is unable to repay debt, and I want to make this A Limited as a bankrupt or goes into liquidation. Or even A Limited voluntarily can go to the IBC court, that is NCLT, and say that I am unable to meet my debt, please discharge me from the liability. So for that, for declaring that conclusion for that dispute, on that particular dispute that has been arises, so such decision will be either for bankruptcy or for liquidation. And if this A Limited it was a person or individual, then it was a bankruptcy, and if it is an company, then they can give an order of liquidation, and on that liquidation obviously this 50,000 asset will be given to Mr. A, and if any other from creditors or any other debtors of the A Limited, any dues was left and any other thing was from any other thing is there, any property is there from which the recovery could be done, then after completing that recovery, the Mr. A will be repaid. The whatever amount is A Limited is having left with will be repaid to Mr. A, and now A Limited will get basically bankrupt, and all the liabilities of A Limited will get ended with this bankruptcy, and it may also lead to the winding up of that company. Okay, so what the bankruptcy word says, it says it is a legal proceedings which involves a person or a business, that also include a sole proprietor, who is unable to repay the outstanding debt, and bankruptcy process begins with a petition filed by the debtor or a creditor. So basically they file the petition, that is a Mr. A here can file the petition to NCLT, okay, and all the debtor's assets are measured and evaluated, and the asset may be used to repay the portion of outstanding debt. So basically they will see first of all what assets the company have and what all the debtors the company have. Debtors means a person from whom the company has to recover the money. So they estimate the amount of recovery the company or a firm or an individual need to do from any person. All these things are estimated, and on the basis of where it is determined that how much portion can be of the outstanding debt can be repaid. And if any person or entity is unable to pay off the entire debt it owes to their creditor on time, or as and when it becomes due and payable, such entity or person will be regarded as insolvent. So it is a basically situation that happens when a person is unable to pay his due timely, whatever the time was decided, on that time he is unable to pay off its debt to its creditor or any other person. In such a situation, such a company or person or individual will be called as insolvent. And liquidation is basically a winding up of the company or a incorporated entity, and there are many entities that can initiate the proceedings to cause for liquidation. The situation is same for liquidation also, that the person becomes insolvent, the company becomes insolvent, or body corporate or LLP becomes insolvent. On becoming insolvent, the liquidation making company to liquidate, they want the company to get liquidated. So for that the basically application to NCLT can be filed by following person: either regulatory bodies, that is ROC or SEBI or any other regulatory body, or RBI or any other regulatory body, or directors of the company, okay, or shareholders of the company, or any unpaid creditor of the company. So they can file an application to the NCLT that we want a company to go into the liquidation. So what is the summary? In a nutshell, insolvency is common to both bankruptcy and liquidation. So insolvency is actually the first step for going towards bankruptcy or liquidation. And the situation is what? That they are not able to pay the debt as and when it becomes due and payable, and it causes a liquidation, and it is the only way that causes a natural person to become a bankrupt. So if it's a company who's become insolvent, it will go into liquidation. If it is unable to recover it or resolve it, and if it is an individual or a person, basically it may be a business. So in that case, if it becomes insolvent, if he becomes insolvent, then there is a you can say there is a situation, either you can go for recovery or resolution, or if it cannot be done, then you need to go for liquidation. Now the next is Insolvency and Bankruptcy Code. So what it says, the code seeks to provide an effective legal framework for timely resolution of insolvency and bankruptcy, which would support development of credit markets and encourage entrepreneurship and facilitate more investment, leading to higher economic growth. So basically what happens that normally there are in a business, while a person is continuing a business, running a business, there may be a situation that arises at a number of times which may lead to that business or a company to become insolvent. So basically there was a legal framework that requires for timely resolution of insolvency and bankruptcy, and to be very honest, the first thing that everyone wants in this code is to revive the company. I hope, or I think you have heard the word SICA, that is sick. One second. Sick Industrial Companies Act. So basically what was done in this act is there was a sick companies concept, that is when a asset of the company become less than the liabilities of the company. So when this is a situation, what happens that a company is called as sick company because it needs a helping hand to revive its company. So whenever a company becomes sick, okay, whenever a company becomes weak, it is a duty of the nation, because we want our GDP to increase, we want our economy to grow. So we don't want any company to die like just normal like this. So we want to give an immense opportunity to everyone to revive, to recover, and to rebuild themselves. So that's why there is an option which is given under SICA, and that is now repealed, and IBC has come instead of this. So the purpose of SICA was basically to revive the sick company. So earlier the plan was used to made in this SICA, where we can, with that particular plan, we can do the resolution of the company. Okay. And if this plan is able to implement and resolve, company will recover. And if it is unable to implement and there is no scope that the company could revive, then the company goes into liquidation. So there is a liquidation or winding up was a last resort for the company. So it's not like that a company gets insolvent, chalo we will do now liquidation. No, it is not the thing. The main idea is first we want to revive the company, and then we want then if it is unable to get revived, even after we have tried a lot and then also anything is not working, then we can go for liquidation. Okay, so what is written here, it is the same thing. It says basically it is a legal framework which is made for timely resolution of insolvency and bankruptcy, which would support development of credit markets and encourage entrepreneurship. Why encourage entrepreneurship? Basically, if even for creditor also it leads to faster recovery, and the entrepreneurship, that is the business, so sole proprietors or the businessmen basically we have. So they are basically able to survive more efficiently, and they will able to recover their money more effectively and more fastly. Okay, so it will help us in developing the credit market as well, and facilitate more investment, leading to high economic growth and development. Because the creditors also know that we have an option. If the company is unable to pay the debts to us, we can go to IBC, to NCLT under IBC, to basically take an action against such a company who is not giving us the money so that we are entitled to get. So if they feel such a security, they will obviously do the more investment in the economy that will lead to higher economic growth and development of the country. So there are certain features of IBC. First, it is a comprehensive law because it contains everything in that self. What everything? It contains insolvency and bankruptcy for all the persons, including corporates, partnership firm, LLP, and individuals. So it is a complete code for insolvency and bankruptcy thing, which provides insolvency and bankruptcy for all the person, including individual, company, partnership firm, LLP. Okay, and there is no multiplicity of law because in this particular thing only and only IBC is applicable, nothing else. Every other act which was creating multiplicity of law, that is the act like a SICA Act, Sikh Industrial Companies Act, these are repealed, and in place of these act, IBC 2016 has come up. So it is basically gives you a feature of no multiplicity of law. What it says, this code has withered away the multiple laws, that is removed the multiple laws covering the recovery of debt and insolvency and liquidation process, and it presents a single platform for all the reliefs related to recovery of debt and insolvency. It also provides the provision for liquidation, voluntary liquidation. So it's a complete code in itself. Low time resolution, so faster resolution of the issue of recovery of debt and insolvency. So the time that we have, it need to be completed within 180 days, and then further one extension is allowed for maximum 90 days. And in this, you can go for fast track resolution also, and that can be done within 90 days. Okay, and in total 180 plus 90 days, that is in 270 days maximum your case will solve. But right now there is an and basically amendment has come which will give you a further time period of 60 days. This 60 days is given to complete your pending litigations if you have any, and that's how you are getting total time of 330 days. Okay, and this is one window clearance, that has been drafted to provide one window clearance to the applicant, whereby he gets the appropriate relief at the same authority. That is only one authority we have here, that is NCLT. Okay, and you have to go to NCLT only to provide to get the relief in the above matter. Okay, unlike the earlier position of the law, where in the case of the company is unable to revive the procedure of winding up and liquidation has to be initiated under separate laws. But now we have only one authority, that is NCLT, who will going to see all the cases related to the debt and recovery of debt and insolvency. One chain authority. Now what does mean? What do you mean by this? There is a one chain authority under this code, that is you have an NCLT and NCLAT. That's it. Okay, so and now civil court will not interfere in the application which is filed before NCLT. So any application with respect to IBC, if it is filed with NCLT, then civil court does not have any authority to basically interfere in this proceedings. Okay, and therefore it reduces the multiplicity of litigations. So there is multiple litigation cannot be basically filed against the company on the same matter or with respect to the same jurisdiction that we have in the NCLT. So they are not filing in different courts or something. They need to file at one place. So multiplicity of litigation is avoided. NCLT will adjudicate the insolvency resolution for companies, and debt recovery tribunal will adjudicate insolvency resolution for individual. Now there is one thing, that if you are a company then you will go like this, NCLT and NCLT. Okay, and if you are person, or you can say individual, then for you the authority is DRT, Debt Recovery Tribunal, and DRAT. This is adjudicating authority and this is appellant authority. Okay, and again this is adjudicating authority. The company will first go to NCLT, and if it has any complaint then it will go to NCLT, that is appellant authority. Okay, now priority will be given to the interest of workmen and employees. So this code will also provide the interest of workmen and employees. If interest doesn't mean that simple interest wala interest, this interest is the right, and right of workmen and employees are basically being protected here. The decision will be given in the favor of this people. Okay, and it includes, it basically excludes the dues which is payable to workmen under PF, pension fund, gratuity fund from the debtor's assets under liquidation. So if under PF or pension fund or gratuity fund anything needs to be paid, it is excluded, but the salary part and everything is basically included and their interest is protected under this code. Now new regulatory authority. Now it provides the constitution of new regulatory authority under which is named as IBBI, that is Insolvency and Bankruptcy Board of India, to regulate the profession. What its purpose? What is purpose? So basically it regulates the profession. What professionals? Professionals like us, CA, CS, CMA. So basically we can become an insolvency professional who help the company to get revive of that insolvency. So such professionals are regulated by Insolvency Bankruptcy Board of India, and these professionals are regulated by Insolvency Professional Agency like ICSI, ICAI, ICMAI. So these agencies are also regulated by IBBI, and the information utilities are also a thing which is made under this code, which basically have the work to basically collect and have the record of the company and to provide this information to the professionals or other people who are basically needing such information with the purpose to revive the company or to know more about that insolvent company. So basically this information utilities has been made under IBC and it has been regulated by IBBI. Okay, and it is basically engaged in the resolution. These all people are engaged in the resolution of insolvencies of company, partnership firm and individual, and the board, that is IBBI, has already been established and it has started functioning. So it is currently running. You can even explore the website of IBBI for your more better practical knowledge. Now this code is made for a purpose. So what is the purpose behind making this code? Basically they want to create a balance between the stakeholders' interest and the business enterprise, maybe the company or individual, so that they can avail the facility of credit and at the same time creditor will not bear the losses. So what is the pros and cons to both of the party? First, the parties, that is the company, individual, body corporate, firm, LLP, they are able to obtain credit because creditors have the surety that they will recover the money at any cost, and creditor will also get protected from the losses that they can face if the company does any default. Now the purpose of this IBC is as follows. First, it consolidate and amend the various laws related to reorganization and insolvency resolution of corporate person, partnership firm and individual. As this code is a single code, a comprehensive code, single window, which provides the all rules for the recovery of debt and insolvency of all the people, that is corporate person, partnership firm and individual. Earlier there were different laws which is made for this particular thing in different acts. So now the amendment has made in such a manner that every person has to come under this code if they want to recover their debt and the insolvency that has been happened. Now the next motive is to fix the time period for this particular solvency of this case, how it will be solved within a fixed time period. So time period that we have discussed is 180 days plus 90 days extension plus 60 days extension for pending litigation. So this is total 330 days. Okay. Now, to maximize the value of asset of the interested person. So, in a case where a company is unable to repay the debt and we are not able to revive anything, now basically it's a duty of insolvency professional to sell the asset in a manner that will by which we can get the maximum value of the asset which is being sold. So that is again a purpose of this code, that we want to give the maximum value of the asset to the interested person, that is the stakeholders of the company, that is a creditor and every other person who is entitled to get the money from the company. And to promote the entrepreneurship, that is to promote the business. Okay, like right now Modi ji is promoting that everyone should do their own business to become an Atmanirbhar Bharat. So this code will give an edge to such a kind of motives that our Modi ji gives us. Okay, to increase the availability of credit. Now we want to increase the availability of credit, and because as the credit is given, the more the credit is given, the more the company is able to do the business or expand the business. So credit is basically an integral part and an important part of running the business effectively. So to increase the availability of credit is basically the IBC works for, because if the creditors gets an assurity that our money is safe, then obviously they will give more and more credit. Now to balance the interest of all stakeholders and with the company. So basically it ensures that the interest of all stakeholders are being protected. Okay. To establish an Insolvency Bankruptcy Board of India as a regulatory body of Insolvency Bankruptcy Code. So who is the regulatory body of under IBC? That is Insolvency Bankruptcy Board of India, that we have discussed in brief right now. Okay. Now this is the regulatory mechanism. It's a very important thing. So basically it says this IBC has set up a new regulatory mechanism with institutional setup comprising of 5 pillars. So there are 5 pillars of IBC. First, it is Insolvency Bankruptcy Board. Under this, we have seen there are 3 things which IBBI regulates. That is Insolvency Professional Agency, Insolvency Professional, and the last is Information Utility. And this is Adjudicating Authority, that is NCLT or DRT. NCLT in case of company or body corporate, DRT in case of individual or business. Okay. So we'll discuss one by one each in detail, and this is a very important part and description of each and every point, that is IBBI, IPA, IP, IU, Adjudicating Authority, everything is important. So these all points 1, 2, 3, 4, 5. So these 5 points are very important for exam point of view. You may get a short note on any of them. Now what it says, the Insolvency and Bankruptcy Board of India, the code provides for establishment of a regulator who will oversee the work of this IBBI is it will oversee these entities and will perform legislative, executive and quasi-judicial function. Okay, legislative is like basically it will basically regulate the function of these body and can take any disciplinary action against these people, or basically can give some guidelines, issue some code of conduct for these people. And it's like a act as a quasi judicial function. It's not like a proper code, but it's a quasi judicial function, that is some authority of the courts are basically being given to Insolvency and Bankruptcy Board of India with respect to these three people, that is Insolvency Professional Agency and Information Utility. So for these people, regulator will play the role and function of legislative, executive and quasi-judicial thing, and with respect to these people, okay, and will oversee these entities and regulate these entities, can make the code of conduct for these entities, can take a disciplinary action against these entities, okay. And this board has been established on 1st October 2016 and his head office is located in New Delhi, okay, it's located at New Delhi, and it is a body corporate, so it has all the features that a body corporate have, like it has a perpetual succession, that is it will not end because of the death of any partner, it keeps on going, and it has a common seal. It has an power to acquire, hold and dispose of any property, that is to purchase any property, to keep any property and to sell off any property, and such property can be movable and immovable, and it has the ability to contract, and it can be sue or it can be sued. Basically a case can be filed against this particular entity IBBI, and IBBI also can file a case against any particular person. Now the next is Insolvency Professional Agency. So they are like ICAI, ICSI, ICMAI. So we have these institute who regulates us. So similarly, Insolvency Professional Agency is a kind of institute which regulates the insolvency professionals. So the code provides for establishment of this Insolvency Professional Agency and to enroll. So what it will does, it will enroll in itself and regulate the insolvency professional as its member in accordance with IBC 2016 and read with regulation. And it will perform the following functions. So basically what it says, IPA, basically in that members will enroll themselves as an insolvency professionals, and the work of IPA is basically to regulate these professionals. So the main three function is regulatory function, executive function and quasi-judicial function. So what is the regulatory function? So they'll draft a detailed standards, code of conduct and bylaws that are made public and will be binding on all the members. So in that the code of conduct is made for members. An executive function, in this the monitoring, inspecting and investigation can be done of the members of Insolvency Professional Agency on regular basis, and it will gather the information on their performance. So the performance will also be checked by these institute of the professionals, and also basically they want to see that whether we have a quality professionals with us or not, and if there is any malfeasance, that is a breach in the conduct of IP insolvency professional duties, then it will also be checked by IPA. And if any such thing is done on this, if any action needs to be taken against these particular people, insolvency professionals who are not performing well, or who is basically not performing well, or on inspection we have find some wrong thing, or has done the breach of conduct under its IP duties, then any disciplinary action can also be taken by IPA. And quasi-judicial function, So what the quasi-judicial function of IPA is, addressing the grievances of aggrieved party. So any party, if it is aggrieved, any client is aggrieved by the actions of insolvency professionals, they can raise their complaint to the insolvency professional agency, and these agency will hear such complaint and try to resolve it as fast as possible. So they'll hear such complaints against the member and it will take the suitable action. Now the third is insolvency professionals. These are actually the people who are going to perform the insolvency resolution thing. So they are the executor of this code. So this code provides for insolvency professional. These are like intermediaries who would play an important role in efficient working of bankruptcy process. And the role of the IP, that is insolvency professional, encompasses a wider range of function which includes adhering to procedure of the law as well as accounting and finance related functions. So what are the functions of IP? Basically they ensure that the procedure of the law is being followed, and will also take care of accounting and finance related functions. And he shall have the power and responsibility to monitor and manage the operation and the asset of the company. So they have the power and responsibility. They have the power and responsibility to monitor and manage the operation and asset of enterprise. Which enterprise? It's the client who has hired that insolvency professional to do this insolvency resolution thing in their organization. So in that organization, it will monitor the operations and asset of that organization, and it will manage the operation and asset in such a way that we want to revive such a company. And in this resolution process, he verifies the claims. He'll raise the claim of creditor. He will check that who all the creditors are there of the company to whom the payment need to be made. So he will verify their claims, that the claims are genuine or not, and it will constitute a creditor committee and will run the business of that insolvent person, that is the debtor's business, during the moratorium period. Moratorium period is a stay period during which is basically a stay has been put on the company which we wants to revive for a particular period, that may be a period of insolvency, that we'll see in the later videos, that will be of 180 days. So for this 180 days, this moratorium period, in that the business will be run by the insolvency professional. It will basically list out the claims of creditor and verify them. Then it will constitute a creditor committee on the basis of the claims, and will run the business of the debtor, that is the insolvent person, during this moratorium period, and will help the creditor in reaching a conclusion for a revival plan. Consensus, that is all the creditors will come to a mutual decision on that particular revival plan. There are various plans that has been formed, and on a particular plan, when all the creditors get agrees, that plan will be get executed. So in liquidation, when the company goes into liquidation, this insolvency professional act as a liquidator also, and as a bankruptcy trustee. So when a company goes into liquidation, then also insolvency professional has something to do. What? It becomes as a liquidator of the company and an insolvency bankruptcy trustee. And insolvency professional, if appointed as a resolution professional, that is, insolvency professional is basically appointed at the time when this application is filed to the NCLT, that we want to that company should goes into insolvency. That time insolvency professional is appointed, and when after making the committee appoints an insolvency professional as a resolution professional who will be acting to resolve the issues of the company. Okay. And in that, he will act as a neutral trustee of the assets of the organization. So he'll take care of the assets of the organization, and it will sold the asset of the company in such a way that will be beneficial for the interest of the company and all these stakeholders. Now, every insolvency professional shall abide by following code of conduct. So they need to follow the following code of conduct. They need to take care and reasonable care and diligence while performing their duties. They need to comply with the all requirement and terms and conditions of the code of conduct which is framed by IPA. We have already discussed this. And they need to allow these Insolvency Professional Agency to inspect this record. We have already discussed that IPA has the right to inspect the record of Insolvency Professional, and they will submit a copy of records of every proceeding. So every proceedings before adjudicating authority to the board, that is board here is IBBI, as well as to the Insolvency Professional Agency of which he is a member. So basically, whenever a proceedings has been handled by that insolvency professional in a company, so the records of that particular proceedings need, which is basically proceedings which is done before NCLT. So the copy of this proceedings need to be given to IBBI and Insolvency Bankruptcy Agency. Okay, Insolvency Professional Agency, in which he is a member, and he need to perform his function in such a manner and subject to such condition as may be specified in the rules or in the bylaws of the company or in any other manner. Okay, so basically these are the basic duties of insolvency professional. And for your knowledge, insolvency professional can be a CA, CS, CMA, practicing CA, CS, CMA. Okay. Now, we'll take this information utility part in the next video, and adjudicating authority. And with this, just for your knowledge, I'm going to tell you that this will take around 8 to 9 hours for me to complete entire IBC. Okay. So have patience, and I want you to understand everything in detail. So I am teaching it to you accordingly. Okay. Thank you.